The Sac and Fox tribe was created as a result of the Treaty of St. Louis in 1804. This treaty combined the Sauk and Meskwaki, or Fox people, in an agreement to cede away a large amount of the two tribes' land to the United States. The Sac and Fox people have multiple treaty agreements with the U.S. government. The Sauks had been in treaty agreements with the U.S. from as early as January 9, 1789. A treaty is an agreement made between two sovereign nations. Treaties are a way for each nation to agree how they will relate to one another. Most of the tribes in the U.S. have relationships with the government based upon treaties. However, tribes have had their sovereignty and a government that predates the U.S. Constitution. Tribal sovereignty is not defined, but is recognized in the U.S. Constitution, Article 6, Clause 2. This Constitution, and the laws of the United States, which shall be made in the pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. There have been more than 370 ratified treaties that have helped the United States expand its territory. With every treaty was the loss of tribal lands. Lands were ceded to the U.S. through treaties in exchange for the tribe's economic security and provisions. Many treaties left the tribes with broken promises, and most tribes were removed from their homelands and placed in less desirable territories. With the removed tribes' failure to assimilate and the encroachment of white settlers expanding into the West, Congress passed the Dawes Severalty Act in 1887. Named after its creator, Senator Henry L. Dawes of Massachusetts, the Dawes Act was meant to abolish tribal land ownership and stimulate the assimilation process. The act would break up reservations into individual allotments to individual tribal members, creating what is known as Indian country.
Indian country is kind of a specialized term that has a specific meaning. It comes from the United States codes, meaning that is it a land validly set apart for Indians for their use as Indians. It's not just whether an Indian owns it, but are they being allowed to own it and use it because they are federally recognized tribal members, or the tribe is federally recognized.
All allotments would be held in trust by the U.S. government for 25 years, after which the tribal member would receive United States citizenship entitled to the allotted land. Tribal lands that were not allotted were to be sold to the United States to be open for homesteading. When the allotment process began in 1887, tribal land holdings in the U.S. was 138 million acres. By the time the allotment period ended, that number was reduced to 47 million acres. The United States was trying to solve the Indian problem through forced assimilation. Children were sent away to boarding schools to civilize them. A quote from the founder of the Carlisle Indian Industrial School, Richard H. Pratt, on the education of Native Americans. A great general has said the only good Indian is a dead one, and that high sanction of his destruction has been an enormous factor in promoting Indian massacres. In a sense, I agree with the sentiment, but only in this, that all the Indian there is in the race should be dead. Kill the Indian in him and save the man. Following the Dawes Act of 1887, the Indian Reorganization Act enacted by Congress aimed at decreasing federal control of American Indian affairs and increased Indian self-government and responsibility. Today, the Reorganization Act remains the basis of federal legislation concerning Indian affairs. Sac and Fox governments, traditional and new, have been challenged with threats to the sovereignty of the nation over lands, resources, and the people's welfare. Recent tribal leadership has defended the sovereignty rights of the Sac and Fox Nation. Today, they continue to fight to protect their sovereign control over lands, resources, and govern according to their own modern law. In 1983, the Sac and Fox Nation amended its tax laws to impose a tax on motor vehicles owned by residents of the tribal jurisdiction.
In October of 1983, Sac and Fox began issuing their own license plates. They issued motor vehicle titles and registrations, and that became the first real act of tribal sovereignty and an exercise of tribal self-government.
Tribal tags and plates were already being issued by other tribes years before any were distributed in the state of Oklahoma. The very first tribal vehicle tag issued was by the Seminole Tribe of Florida in 1942. The Sac and Fox Nation made state history when a tribal member and Shawnee resident was the first recipient of a Sac and Fox Nation tribal license plate. This marked the beginning of a statewide controversy over whether tribal motorists were required to continue to pay state tax and display state tags on their vehicles. Tribal members declined to pay additional state auto taxes, and the response was not a positive one. State highway patrolmen in Potawatomi and Lincoln counties began stopping tribal motorists and issuing citations for the crimes of improper tag display and failure to pay taxes due the state. The tribe was forced to represent each ticketed tribal member in municipal, county, and state traffic courts, even though every state and local prosecution was dismissed for lack of jurisdiction. A gentleman's agreement was struck between Governor George Nye, Attorney General Mike Turpin, the Department of Public Safety, and the Chief of the Oklahoma Highway Patrol that law enforcement officers will not stop or detain SAC and FOX motorists simply for displaying a tribal vehicle tag. The agreement was unsuccessful in stopping the harassment of SAC and FOX motorists with tribal license plates.
That's when the parade officer pulled me over. They had us get out of the vehicle, standing on the side of the road that night, and rifled that vehicle. They took the seats out, checked the trunk, under the hood, everything, and they wouldn't tell me what they were looking for. They didn't find anything, but the next thing I knew, a wrecker was hooked up to my car and towed it off. And we were left stranded on the side of the road to somehow make it back to our homes in Shawnee, which is about 30 miles away.
Vehicles were continually ticketed, impounded, and subject to unlawful search and seizure. Local and state courts always dismissed all of the traffic charges in each case. Even after the local and state courts continually dismissed traffic charges, state tax officials attempted to collect back taxes, penalties, and interest from any non-tribal purchaser of a vehicle owned by a tribal member whose vehicle was tagged by the SAC and FOX Nation. This state practice was creating a situation where tribal members' vehicles had little value and made them almost completely unmarketable for resale. This attempt by the Oklahoma state tax officials and the breach of their gentleman's agreement is what prompted the SAC and FOX Nation to file a federal lawsuit. The SAC and FOX Nation prevailed in the Federal District Court in Oklahoma City, as well as 10th Circuit Court of Appeals in Denver, Colorado. The Oklahoma State Tax Commission appealed the case, asking the U.S. Supreme Court to hear the case, in which they agreed. Arguments from the state were that the state of Oklahoma acknowledged that the SAC and FOX Nation had the rights to impose its own income tax and motor vehicle tax as the state does, but the Allotment Act in 1887 terminated the reservations and treaty agreements.
This case involves whether the state of Oklahoma may tax the income of a tribal member who is employed by the tribe, the SAC and FOX Nation, and whether Oklahoma may impose motor vehicle taxes on automobiles owned by tribal members of the SAC and FOX Nation. So that in this case, even on Indian country, within Oklahoma, individuals living on Indian country are taxable by the state in Oklahoma. Now that is because in 1891, the federal government, Congress, passed the allotment agreement or enacted the allotment agreement, which allotted all the lands of the reservation to the tribal members at that time.
Arguments from the SAC and FOX Nation were that the tribe has had a power to make and enforce their own laws since before colonization. They felt that the state had trespassed on tribal lands, collected monies in payment of purported taxes due, and unlawfully arrested and issued traffic citations to tribal members with tribal tags without purpose.
The court has ruled previously in several cases in which the court did not recognize that there was an existing Indian reservation, that state taxes, at least as to tribal members within the Indian country, were not applicable. Those cases include Rickard, the Kansas Indians, the New York Indians, several other cases cited in the brief. Now, the state would have you believe that the tribe here is totally subject to state law, that the Indian reservation of the SAC and FOX Nation was abolished back in 1891, and that the tribe is not a tribe in the normal sense of the word. As long as the political branches of the government, as long as the Congress and the executive recognize these as a people with a tribal government having the right to make and enforce their own laws and maintaining governmental relationship with the United States, they're outside the authority of the state to levy taxes.
The United States Supreme Court, in a unanimous 9-0 decision, ruled that the state of Oklahoma must give full faith and credit to the titles and tags issued by the SAC and FOX Nation, just as it would recognize the vehicle registrations and license plates of all other jurisdictions. In spite of all tragedy and the continuous fight for sovereignty, the SAC and FOX Nation was the first in Oklahoma to achieve this victory. Today, all but a few tribes in Oklahoma issue tags and license plates. In honor of their triumph, the SAC and FOX Nation celebrates May 17th each year as their national holiday called Victory Day.